Hello, everyone, and welcome to Crime in Court. My name is Heather, and this is a deep dive in the Delphi homicides. We are going to be going over some new court documents that just dropped, like fresh, hot off the press, that yesterday, like late in the afternoon slash evening. So we're going to go over these. And so first off, we're going to go over NBC has now entered the chat. Dateline NBC wants trial exhibits, which there's been some issues getting trial exhibits from all over. Everyone has been doing FOIA requests and they're getting the roundabout answers. So we'll get into that. And we're also going to talk about the response from the Commonwealth regarding the correction for errors, the motion to correct errors that Richard Allen and his team had filed afterwards. They need it corrected so that they can do their appeal appropriately. And they want it correct. They want some things corrected for the record. So we'll look at all of that and then some. So let's get started. Please hit that like button and let's begin. All right. So this first motion we're going to look through is a limited appearance by attorneys. So this is intervening is the party classification. Number one, the undersigned attorney and all attorneys listed on this form now appear in this case for the limited sole purpose of seeking access to public trial exhibits following denial of its request by the court reporter of Allen County. This limited appearance is on behalf of the following party members: NBC Universal Media LLC, applicable attorney information, Margaret M. Christensen and Jessica Lauren Meek will be coming on from Denton's Brigham Greenbaum LLP. And there are other party members. No, okay. If first initiating party filing, this case, okay, I don't know. Do we need to read all of this? I will accept service of facts. This case involves support issues. No. They are related cases. No. This form is served on other parties. Yes. So who was it served to? We don't see. The clerk of Carroll County as well. Probably. I certify that the foregoing was filed with the clerk of Carroll County. So I wonder, are the files with Allen County or Clark County? Because remember, they changed jurisdictions for a, more less saturation of media, I guess, and how the public bias in that town was being portrayed. So they did switch to Allen County when it's Carroll County, and so I wonder how that affects it. But either way, somebody needs to be housing the exhibits and allowing the non-sealed exhibits to be open and available to the public. So it's ridiculous that they're holding on to it. So let's read this quick, semi short motion from NBCU's um, Universal Studios. All right, so NBC Universal Media LLC by counsel respectfully moves to intervene in this action for the sole purpose of seeking access to public trial exhibits following denial of its requests for the court reporter of Allen County, the court reporter here and after. All right, so in support, NBCU states the following factual background. NBCU is one of the world's leading media companies and produces Dateline NBC. So that's where Dateline comes in. They are probably doing an episode, probably, I assume, with the family, making it all sympathetic to the family, which, like, that's fine. But portraying Richard Allen as the guilty party, I bet, is what they're probably going to do. Because if most shows and productions do that, let's just say, if you notice. And that's why we're here on YouTube to find the facts. So, NBC is one of the world's leading media companies and produces Dateline NBC, a weekly news program focusing on significant legal proceedings and investigations throughout the country. In fact, I think Dateline might have already done an episode or two on this case. On January 8th, 2025, NBCU sent the court reporter a public records request pursuant to the Indiana Records Act seeking copies of public exhibits admitted during the trial. So the public exhibits, the ones that are available to the public, not sealed, we're asking for access, that they were admitted during the trial in this case. In its request, NBCU specifically excluded exhibits under seal. So we're not asking for anything that was under seal. We're just asking for all of the public exhibits. In acknowledgement that the public trial exhibits are voluminous, NBCU requested that the court reporter prioritize requests for one, any and all recorded police interviews with Richard Allen, video and audio, and two, any and all recorded prison phone calls between Richard Allen, his wife, his mother, and audio. The court reporter responded as follows: I am in receipt of your request for release of exhibits. Perhaps at some point in the future, media may be permitted to view the exhibits that are not sealed and confidential pursuant to the Indiana rules of public access or court order at a time and date the court determines, but it would be after the filing of the transcript with the Indiana Court of Appeals, as the exhibits are required for that purpose. What the hell does it matter if you release the exhibits first before the transcript is released? This is just BS that that Judge Gull is pulling because she probably said under no circumstances can anybody get anything from a FOIA request. Because she's been hiding records from the beginning, as we know. She's been taking them off the docket, and she was ordered to put them back by the Supreme Court. So, or Superior Court, not Supreme, but whatever. NBCU asked if there is a way to know when the transcript will be filed, and the court reporter replied, an entry for a notice of filing of transcript will be made in the online docket when the transcript has been filed. As the date of this filing, it does not, so this came out yesterday, February 4th. As the date of this filing, it does not appear that any notice of appeal has been filed. After receiving the denial, NBCU, out of an abundance of caution, sent materially similar requests to the Carroll County Clerk. So they did request it from Allen and County on January 24th, 2025. The request to Carroll County sought priority access to the specific exhibits identified in the request to Allen County, along with a request for priority access to the 43-second cell phone video clip recorded by Liberty German. So that 43-second clip that no one else saw except the jury. Because they blocked it. They hid it from the rest of the public, I believe. And those who did see anything were like, yeah, you can't see anything on the video. So I don't know. The Carroll County Clerk responded on January 27th, 2025, stating that the requested exhibits would have to be requested through the Allen County reporter, and that these exhibits may or may not be available, and that will be up to the judge, which no judge, it ain't up to you. These are public. It's public. These courts are supposed to be public. So that's why this motion to intervene. Because the Allen County Court reporter has denied the request, and because the Carroll County Clerk blah, blah, blah. I'm already getting tongue-tied. This isn't great. Let me start that over. Because the Allen County Court reporter has denied the request, and because the Carroll County Clerk referred NBCU to the Allen County Court reporter, NBCU lacks further recourse without court intervention. Yeah, because they're just basically sending them around in circles on purpose. Accordingly, NBCU requests leave to intervene in this action for the limited purpose of seeking access to the public trial exhibits as requested with priority access to the following exhibits: any and all recorded police interviews with Richard Allen, video and audio, any and all recorded prison phone calls between Richard Allen, his wife, his mother, and just audio, and three, the 43-second cell phone video clip recorded by Liberty German. Together, the priority requests, those are all together the priority requests. MECU seeks intervention for this limited purpose as a surrogate for the public. So they are intervening and saying, we're going to be a surrogate for the public. Well, then you got to get everything. You got to push for everything. But I get, you got to be, you got, when they're fighting back, you got to be less stringent on your demands, but or when they're not giving you what you want, you gotta, maybe you feel like you have to acquiesce more to them. But I don't know. If you're gonna be the surrogate to the public, you need to prioritize all of it and not just certain portions of it that are what you think show Richard Allen's guilt. Because there are things that should be requested, I believe, that could show his innocence, and they didn't ask for any of that. So why not? You got to ask. You got to wonder because they're a media source, they're a big media conglomerate. They have their own agenda to push. Motion to compel access to public trial exhibits the public's right to access. The Indiana General Assembly expressly recognizes Indiana's public policy that all persons are entitled to full and complete information regarding the affairs of government and official acts of those who represent them as public officials and employees. So that means cops, DAs, whoever. We have a right to that information, to those official acts. We have a right to scrutinize it, but for some reason they're not allowing us to because they don't want us to. This is further explaining that APRA will be liberally construed to implement this policy and that the burden for non-disclosure falls on the public agency. The Supreme Court, in promulgating the rules on access to court records, likewise recognizes a presumption of openness and requires compelling evidence to overcome the presumption. The ACR Rule 6, with the objective of providing maximum publicity or maximum public accessibility to court records. So that should be the standard. We should have maximum public access. Apart from well-reasoned policy considerations, the public interest in accessing judicial records has constitutional dimensions. NBCU, as a member and representative of the public, is presumptively entitled to judicial documents and proceedings under the First and 14th Amendments to the United States Constitution. It is clear that the courts of this country recognize a general right to inspect and copy public records and documents, including judicial records and documents. Ooh, I would love to see certain um, discovery judicial records of Judge Gull. Maybe some emails, some personal emails, or some emails with public officials talking about this case, perhaps, and making sure that Richard Allen gets a guilty conviction. I don't know. I'm just speculating, but perhaps maybe there's something there. The Indiana Constitution, similarly and arguably more so, protects public access and key news gathering activities. No law shall be passed restraining the free interchange of thought and opinion or restricting the right to speak, write, or print freely on any subject whatsoever. By her keeping this information from us, because it's up to the judge, according to the one county clerk, um, it's not, though. It's really not up to the judge. She's basically infringing on our constitutional rights. Recognizing that the Indiana Constitution more jealously protects freedom of speech guarantees that than does the United States Constitution. In light of Indiana's constitutional protection of the free interchange of ideas, the Indiana Supreme Court has assumed that a material burden or news gathering ability could violate the Indiana Constitution. So there's a good argument that she's violating Indiana Constitution for the news gathering ability. She's not allowing us to report on it. Considering Indiana's policy favoring public access and the constitutional implications of restricting access to judicial records, the public's and media's interest in accessing public trial exhibits is accorded substantial weight. The court should compel access to public trial exhibits. APRA governs access to court records such as the public trial exhibits requested. The ACR Rule 1, which includes any document created, collected, received, or maintained by a court agency, or a clerk of court in connection to a particular case. So that falls on judge and whatever instruction she's giving the clerk of court, and how they're not following typical protocol to release public information. APRA, maybe it's not Gall. Maybe the instruction's not coming from Gall. Maybe it's coming from the DA's office. I don't know, but it would really be looking into FBI, Pam Bondi. We just got Pam Bondi confirmed, so let's get looking at this. Look at Delphi, look at Canton, Massachusetts. Those are the two places I would start, and Idaho for Brian Koberger too. So APRA allows requests for inspection and or copying of public records so long as they are made with reasonable particularity and are not expected from public access by statute. The request is certainly reasonably particular, sorry, as it encompasses public trial exhibits in this matter and as do the priority requests. So all of it is public. Not sure why we're not getting it. The court reporter correctly did not claim that any APRA exception precluded access. After all, the request itself excludes any exhibits maintained under seal, and the requested exhibits already were shown in open court during trial. So, yeah, again, just reiterating, we're only asking for public. We specifically said we don't need the sealed stuff. Leave that out. Public agencies may not deny or interfere with the public's general right of access and must either 1. Provide the requested documents to the person making the request or allow the person to make copies on the agency's or person's own equipment within a reasonable time that the request is received. So, like, I can come in there with a thumb drive and put it on my own thumb drive. Like, I'll give you a thumb drive, put it on there if, you have it in a file somewhere, which you should. The court reporter's refusal to provide access to the public trial exhibits until after the transcript is filed at the earliest is unreasonable and interferes with the public's right to access. There is no reason that the public trial exhibits cannot be copied and provided to NBCU at the time that the transcript is being prepared at the same time. Unfortunately, it appears that the public record may be held indefinitely absent court intervention. The problem is especially acute given that no notice of appeal has been filed as of the date of this motion. Granting access to the requested exhibits in this case, which has garnered significant public attention, would promote transparency and trust in the judicial system, stating that secrecy of judicial action can only breed ignorance and distrust of courts, and free and robust reporting, criticism, and debate can subject the criminal justice system to the cleansing efforts of exposure and public accountability. So basically, the more transparent you are, the better. Wherefore, NBCU respectfully requests that the court grant NBCU leave to intervene in the above captioned cause for the limited purpose of seeking access to public trial exhibits, compel the court reporter of Allen County to provide copies of the exhibits covered by the priority requests as admitted at trial and not under seal, no later than 3 business days from the date of this order, compel the court reporter. So there's like, you guys got to act fast because we've been waiting on this stuff and it ain't coming. Compel the court reporter of Allen County to provide copies of the remainder of the public trial exhibits as admitted at trial within 10 business days. Awesome. All other just and appropriate relief. Jessica Lauren Meek, who, as we know, was signed on for the limited appearance of arguing this motion and trying to argue for NBCU to get trial exhibits. As you can see, it is going to Special Judge Francis Goal. So we are probably not going to get the response that we want, but in that case, they have the potential to appeal to Supreme Court, which um, definitely Superior Court would want to know when our constitutional rights are being infringed on. So I would think that that might get some traction, hopefully. All right, so here are exhibits. We're going to start here. This is an email from a man named Justin Balding. He's the producer of Dateline in New York. And he is sending a message to Jody Williams, custodian of records, Allen Superior Court. All right, Ms. Williams, please see the attached signed FOIA request. Text below. It says, so we don't have a date of that. Okay. But it says January 8th, 2025. FOIA County, Carroll County case. They give the case number. Dear Ms. Williams, under the Indiana Access to Public Records Act, Dateline NBC is requesting copies of public records that were presented as evidence in the recent trial of Richard Allen. Richard Allen was convicted and has been sentenced. Understanding that some records remain under seal under Judge Gull's order, for example, crime scene and autopsy photos that we would not consider publishing, we would like you to prioritize the release of any and all recorded police interviews with Richard Allen, video and audio, any and all recorded prison phone calls between Allen, his wife, and his mother, audio. The requested information is in the public interest and is critical to the public's understanding to the case against Richard Allen and his defense. The Indiana Access to Public Records Act requires a response time within 7 business days. We would be very grateful if you would let us know. It's obviously been past those 7 business days. If you deny our request, any or all of it, please cite each specific exemption justifying the refusal to release the information and notify me of the appeal procedures available to me under the law. All right, so her response: Good afternoon. I am in receipt of your request of release of exhibits. Perhaps at some point in the future, media may be permitted to view the exhibits that are not under or that are not sealed and confidential pursuant to Indiana rules. So even she's saying like at some point you'll be able to see the public exhibits under the rules or a court order at a time and date that the court determines. So she's saying this is not this is up to the court, not me, basically. But it would be after the filing of the transcript with the Indiana Court of Appeals, as the exhibits are required for that purpose. He says, Good afternoon, Jody. Thank you so much for your prompt response. Is there a way to know when the transcript will be filed? And that is the end of Exhibit 1. Exhibit 2, same gentleman, Justin Balding, is emailing Jessica Baker. January 24th now. So he's been given the runaround from Allen County, and they're not responding to him or appealing. Like I'm sure he's tried to appeal, as he mentioned, and in the motion, and there was no like subject to appeal, no mention of the appeal from them when he tried to appeal their decision not to give them the stuff. They didn't give us the example, so. But anyways, so this is the Carroll County clerk, Ms. Milburn. It's the same email basically, except he adds the 43-second cell phone video clip there. And if you deny, he says, if you deny any and all of this, please cite each exemption. He says multiple news agencies, this is new too, including NBC News, have requested copies of evidence. To date, and to the best of my knowledge, no legal justification has been provided for withholding trial exhibits after the conclusion of the trial. You're not giving us reasons. And now the Carroll County clerk responds and says, Mr. Balding, and this is days later, it might have been over a weekend, perhaps. Yeah, that was a Friday. So the next week, she responds, Mr. Balding, I have received your request for documents. All documents listed below would have to be requested through Jody Williams, Allen County, which he already did. All of these documents may or may not be available. That will be up to the judge. You can reach out to Jody at this email. So, run around. That is it for the NBC trying to get the trial exhibits. What do you guys think about that? I mean, I think it's ridiculous. There are so many YouTube creators and other just concerned citizens out there that have requested these documents as well through the FOIA request. They should be made available publicly. They should be able to have like a link. They should just make a link because so many people are asking for this. Put everything in a link on a page and then send that out to people when they are like a Dropbox or something to that effect. It's not that difficult, but here we are in 2025 and Carroll County and Allen County can't get their crap together and send out the very public exhibits that should be available to the public at any time. But it's not happening. So what's up with that? It just proves they're trying to hide things, in my opinion. All right, so let's move on to the state's response to motion to correct error. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and respectfully objects to the defendant's motion to correct error and would ask the court to deny the same without a hearing. The defendant, and you know she loves to do that. The defendant's motion does not warrant a motion to correct error because a motion for safekeeping filed by this is them trying to save their asses now. The motion for safekeeping filed by the Carroll County Sheriff is not a critical stage of the proceedings, and the evidence concerning Brad Weber, Ron Logan, and Stacey Eldridge is not newly discovered evidence to warrant a new trial. The state would ask the court to consider the following: safekeeping order and 6th, 14th, and 14th Amendments. That the defendant claims that he always likes to start that the defendant claims that his 6th and 14th Amendments were violated because he was deprived counsel at a safekeeping proceeding November 3rd. No, he wasn't deprived counsel. He was denied his own counsel to attend, and he was denied attendance of that hearing. He wasn't even notified of that hearing. That's a whole different thing than just being deprived of counsel. But he was. He was deprived of counsel to the point where he had counsel, he had representation. You guys knew it. There's proof of it. And you know it now, and you're stuck with your tail between your legs, but here you're going to fight it. Okay, cool. Let's keep going. And that the proceeding was at a critical stage. Okay, I read. The defendant further claims that since he did not have a counsel at hearing, the conviction should be overturned. Yes, Yes, it should, because that's how our laws work. When you infringe upon people's constitutional rights, you run that risk of losing that conviction, of being able to charge that person, of going forward with the charge because you didn't follow the law. So, yes, it should be overturned. The IC states that the code states that upon motion by the sheriff alleging that an inmate in a county jail awaiting trial is a danger of serious bodily harm or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat. But in this case, it was his safety that was the concern. So this doesn't apply, and he had every opportunity because he has a constitutional right to deny this transfer because it was regarding his safety only. So if the court finds that the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, but they never found that. So where's your proof that they found that? It shall order the sheriff to transfer the inmate to another county jail or to a facility of the Department of Corrections. That the statute does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. I don't know if that's necessarily true or not, but I don't think that that should be allowed. How can the judge just make a ruling on a motion from one side without representation from the other? That doesn't jive with me. All right, so that the defendant in this case was taken into custody on October 26, 2022, and housed in the Carroll County Jail. That an initial hearing was held on October 28, 2022, where the defendant entered a plea of not guilty. The court advised the defendant of his right to counsel, and the defendant notified the court that he will hire his own counsel. He at no time stated that he had counsel. See order herein attached as States Exhibit 1. We don't have that. We don't have exhibits, sorry, unfortunately. That after the initial hearing, the defendant was moved to the White County Jail due to overcrowding at the Carroll County Jail. He was not moved to the White County Jail due to the safekeeping order. I don't know if that's accurate either. That on the November 2nd, 2022, the Carroll County Sheriff Tobe Lesenby filed a request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping, commonly referred to a motion for safekeeping, herein attached as States Exhibit 2. That on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein attached. Wait, that's the safekeeping order, though. He didn't say that he was going to be not representing Alan until after the safekeeping hearing took place. That on November 3rd, 2022, the court granted the sheriff's motion without a hearing and determined that the defendant was in imminent danger of seriously bodily harm or death or represents a substantial threat to the safety of others. No, he did not. The reason for the safekeeping was for his own safety. This is all BS. This is Nick McLeland blowing smoke up our butts. But by the insistence on public information, noting that it is extremely dangerous and put all public servants in a dangerous situation. That in this order, the court further noted that the defendant intended on hiring private counsel, further supporting that no attorney had entered their appearance of counsel of record for the defendant. That's not true. We had receipts from the defense of emails from the attorney reaching out, saying he reached out to the Carroll County Sheriff and Nick McLeland and said he was representing Alan. he had been reached out, or he had been contacted by Kathy, his wife, and she retained counsel. And that's when he sent those emails. That a motion for safekeeping is not considered a critical stage of the proceedings where the defendant is required to be present with counsel. He had a right to be there with counsel. That's the issue. He had a right to be there. That the sheriff had standing to file the motion for safekeeping because although the defendant was moved to the White County Jail, he was a Carroll County defendant. He was not moved to the White County Jail because the Carroll County Jail did not have sufficient room to house him in a cell by himself, as evidenced by the affidavit of Tobe Lesenby, herein attached as State's Exhibit 5. So from the beginning, they've been playing games with his incarceration and moving him around and transferring him, and he can't stay here, he can't stay here. So it's just very suspicious that there were so many transfers and done without his attorney when they knew he had an attorney on file. That Judge Diener was the presiding judge over the case at that time and therefore had jurisdiction over the case, and further was within that jurisdiction and within the Indiana Code to make a ruling on the motion without a hearing. That as the filing of the motion for safekeeping, the defendant did not have an attorney of record, BS. That is, you're flat out lying in a proceeding. I mean, a court record. But keep lying, Nick. Let's see what happens. Let's see how the feds like you lying. The Indiana Code does allow that the defendant request a post-transfer hearing, which is what occurred in this case. The defendant requested a hearing on the safekeeping order, and one was held on June 15th. That at the 15th hearing, the court found that the defense's allegations were untruthful and not well-founded and denied the motion to modify the safekeeping. Ay, ay, ay. The court further found that the safekeeping order was reasonable and necessary to ensure the defendant's safety and prevent serious bodily injury to himself, thereby affirming the court's order on November 3rd. These are all just disingenuous facts that he's trying to put on a court document. So we'll see how that goes. Therefore, the defendant had a right to object and exercise that right, and his counsel failed to show the court that the housekeeping or safekeeping order was necessary. In fact, the court found that the defense not only did not meet their burden, but that the evidence presented at the hearing did not support the allegations advanced by defense counsel. Oh, really? You didn't believe them because you're as corrupt as all the others, Nick. That's why. Uh, and the judge, everyone, Tobe, Lesenby, all of them, corrupt. Judge Diener had some ex parte communications that were revealed in one of the latest I think it was a motion to correct error, where Tobe Lesenby was having ex parte communications, one-sided communications with Judge Diener to file the safekeeping order. So he basically got the judge to help him write it, which is a big no-no. So that the defense filed an additional verified motion for immediate transfer of custody on September 18th, 2023, which the court denied without a hearing. That the defendant's due process rights and constitutional rights were protected throughout the course of the case. That under both the Sixth Amendment of the United States Constitution and Article 1, Section 13 of the Indiana Constitution, the right to counsel only applies to critical stages of the prosecution where the absence of counsel might derogate from the accused's right to a fair trial. Further, a stage of the proceedings is only critical if it is one where incrimination may occur or where the opportunity for effective defense must be seized or foregone. The right to counsel is not generalized protection for all purposes. It is not a right that is implicated just because questions of law may arise. You are insane. If you think that he shouldn't have had his attorney present for something as critical as moving him to a solitary confinement, to a solitary cell all day. I mean, that's a critical decision in any proceeding, I would think. That's not something you should do lightly, but here we are. The motion for safekeeping does not touch on matters of guilt or impact the ability to have a fair trial. It is a mechanism for housing the defendant in a penal facility pending trial that will keep him and others safe. The defendant is not facing the advocacy of the prosecutor with respect to his guilt or innocence of the criminal charges. It further is not a stage where incrimination may occur or where the opportunity to present a defense to the charge must be seized or forever be lost or impaired. It has been found that the filing of information is not a critical stage. The probable cause hearing or initial hearings are not critical stages, nor is the procedure to select a special judge. It is safe to surmise that given those rulings, a motion that does not even require a hearing would not be critical stage in the proceedings, which in turn would not entitle the defendant to a new trial. But he asked for the hearing, right? Which is what he was supposed to do. And he was not informed, nor was his counsel, as to attendance when they needed to go, when they needed to attend the hearing, it seems. They were not given the opportunity full outright. It seems like the or not the Commonwealth, the state of Indiana might have been doing a little something nefarious to make sure that maybe they didn't have the opportunity to argue it in court. That since this was not a critical stage of the proceedings, the defendant did not have a Sixth Amendment right to counsel, so he was not denied the Sixth Amendment right to counsel. That even if this was determined to be a critical stage in the proceedings, any Sixth Amendment right to counsel would be reviewable under the harmless error analysis. That the defense cite United States versus Chronic as precedent to overturn the conviction, but they do not, or they do so because they misunderstood the case. The defense believes that the case says that a harmless error analysis is precluded because the defendant has denied counsel at a critical stage. However, the case states that Sixth Amendment violations raise two questions: whether a Sixth Amendment violation has occurred and whether the constitutional violation was harmless. Prejudice must be an element of the constitutional violation to warrant reversal. But it did prejudice him because once he was transferred there and left there hidden where his attorney didn't even know where he was for days or weeks or whatever it was, I can't remember now. They basically they changed his name. They put him in under a pseudonym so no one could find him. How is that not prejudicial? How does that not affect his case when he's not able to discuss things with his attorney in this is a critical stage. He was just arrested. How's it not a critical stage? I don't understand, but cool. Let's keep going. In determining if not having an attorney at a critical stage, wait, did I skip a whole bunch of this? I forgot where I left off now. The defense believes that the case says that a harmless error. Okay. However, the case states that the Sixth Amendment violations raise two questions: whether the violation has occurred and whether the Constitution whether the violation was harmless. Prejudice must be an element of the constitutional violation to warrant reversal. So he was also prejudiced in the fact that once he was there in that particular correctional facility, he was given Dr. Walla, who we know now has been fired, and she may or may not have been talking to people about the case while she was treating him for psychosis and giving him doses of Halidol daily, both in injection form and in pill form, Um, based, I think, to induce a psychosis is what I think she did it for, but that's my opinion. I don't know, can't prove that, but it definitely didn't help him. That's for sure. So in the case of chronic, the issue was ineffective assistance of counsel, not lack of representation at a critical stage. In determining if not having an attorney at a critical stage reaches the level of violation, the harmless error analysis is used. That the lack of hearing for the safekeeping motion on November 3rd, 2022, and the lack of counsel before the decision was made by the court had no effect on the jury's verdict and therefore is harmless. The jury did not find the defendant guilty because a determination of safekeeping was made without a hearing on November 3rd, 2022, and no attorney appeared because no attorney knew. The attorney that he had did not know to appear on that day. Nor did not having an attorney or a hearing at that stage permanently deprive the defendant of the opportunity to raise any claims or assert any defense. After this happened, and he didn't have the opportunity to deny the transfer, they tried to, I believe, get him out of safekeeping multiple times. They've tried, and Judge Gold would just deny it. So, um, yeah, I don't know. That's where we're at. The lack of counsel must be complete to apply the presumption of prejudice, Wright versus Van Patten. The presumption of prejudice only applies when the error affects the entire trial process and necessarily renders it fundamentally unfair. The chronic exception is exceedingly narrow and is only applied in cases of non representation throughout the entire case. Due process under the 14th Amendment as it pertains to the Brad Weber testimony. This is the testimony about the white van, and the timeline is impossible based on what the defense argued in their motion to correct error because they actually had the video. They went back and got the video and the timestamps of when Brad Weber was actually coming home and how it basically dismantles the state's theory, the state's timeline. So here we are, Brad Weber. That the defense argues that the defendant's due process rights under the 14th Amendment of the United States Constitution were violated because the state presented testimony that Brad Weber arrived home in the white van around 2:30 p.m., knowing that the testimony was false before it was elicited or failing to correct it once it had been elicited. The defense cites a video located in discovery from the residence near the Monon High Bridge, a video that was included in the discovery turned over to the defense and that the defense had the entire time of trial. That the exhibit presented by the defense is in the form of a YouTube link that is not identified as an item of evidence by the Indiana State Police number and therefore is an improper submission for consideration by the court. So they did not properly identify it as evidence. It is unverified by legitimate means as to date and time. Defense alleged that the time of the video, or that is why, because it was not legitimized, I guess that's why it was not used. Defense alleged that the time in the video is off by 12 hours without any proof of said allegation except their apparent ability to tell the time by simply looking at the daylight and the moonlight in the video. They further make assumptions about the content of the video. It was saying like it was 2:30 a.m., I think, but likely you could conclude that it was 2:30 p.m. It was just off. By watching the video, they were able to kind of conclude that, and by watching the sun. So they present zero evidence to support said allegations. That the simple answer is that a motion to correct error only applies to newly discovered evidence. From the defense's own admissions, this is not newly discovered evidence, but rather evidence they had been provided long before trial. The defense chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defense trial attorneys. Therefore, it is a moot issue because it is not newly discovered. This, he may have a point, and I guarantee you Judge Gull is going to see it that way, but you can also argue it that it was not it wasn't represented accurately or properly. It wasn't legitimized, I don't know. There might be some kind of argument against that the defense could use, but I don't think they're going to win this one anyways. All right, so that at best, this is impeachable evidence that the defense could have used when Brad Weber was on the stand testifying. Evidence which is merely impeaching is not available as grounds for a new trial under the rules concerning newly discovered evidence. Further evidence must be more than impeachable or cumulative, must not be reasonable, discoverable, reasonably discoverable before trial, and also evidence that would probably result in a different verdict. It must be more than contradictory. Finally, the testimony by Brad Weber was not the exclusive evidence the state used to convict Richard Allen. Brad Weber was used on the stand multiple times, and the defense had every opportunity to cross examine him. If anything, this evidence is no more than impeachment evidence that the defense chose not to use. The defense is not permitted to request a new trial to change strategy when their chosen path fails. This also applies to any phone pings that were in discovery for Brad Weber. This is not newly discovered evidence by the defense's own admissions. Further, at best, it is impeachable evidence that the defense chose not to use at trial. But remember, they had so much evidence being thrown at them, and also it was very difficult to make heads or tails of anything when they got it from prosecution because they intentionally mislabeled things and hid things in files and dug and like buried things deep within the content that they were handing over. Richie Davis claims of the confession by Ron Logan. That the defense next argue that Richie Davis claims that Ron Logan made a confession to him, said claim being newly discovered evidence entitling the defense to a new trial. That any information pertaining to Ron Logan falls under the state's motion in limine concerning third-party motive. The defense had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan but failed to meet their burden with the court. They chose not to present this evidence in that hearing. They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defense to use the motion to correct error in an effort to circumvent their burden concerning third party motive. No, no, they mm, they were barred from talking about any of these things. So, how are they supposed to bring it up? How are they supposed to get in evidence of third party motion or of third party motives when they can't bring up third party individuals? They can't even mention their names. Ron Logan was on that list of people he's not supposed to talk about. So, I don't know. It just baffles me some of the arguments that are coming from this man and how he can be genuine or how he can think that he's genuine in putting this out there. That this evidence, along with the video surveillance evidence from the residence, was received by the defense on January 30th, 2024, as evidenced by the discovery release herein attached as Exhibit 7, that the defense's team, consisting of 3 experienced defense trial attorneys, made a choice not to fully explore or present the Richie Davis claims, which the defense admit was contained in discovery, that the alleged well, they weren't allowed to talk about it, that the alleged confession was made to an inmate at the Department of Corrections named Richie Davis, who is serving 50 years for dealing meth. Got it. That law enforcement interview between Richie Davis, or of Richie Davis, was submitted where he was submitted to a polygraph at his request. That Richie Davis failed the polygraph miserably, that Mr. Davis gave a statement that alleged Ron Logan confessed to him that he took the lives of the girls, the older girl first, and then took the younger one away from the scene, that he took the lives of the second victim later and then brought her back to the scene, that he went back to the scene after search parties searched his property and moved the girls to another location, that he removed the cell phone battery from the girls' phone and left the phone behind, and that he took the girls' clothing from the scene and burned. But they found a lot of the clothing, I thought, no? Many of these details, the only things missing was a pair of underwear and a sock, to my knowledge. Everything else was found. But Libby's things were on Abby, and Abby's things, and a mix of Abby's and Libby's things were in the water, in the creek or whatever. So many of these details are directly contradicted by the evidence. The others have no evidentiary support. That even with the alleged information from Ron Logan about the box cutter, there would not have been enough to establish probable cause to arrest Ron Logan. That's okay, but the FBI went to his home. They did a search, and then that's about the time when the Indiana State Police and Carroll County and Unified Command and all were like, you know what, FBI, you can go home. We don't need you on our case anymore. You might be getting a little too close to the truth, perhaps. So, no evidence places him at the scene of the homicides, unlike the defendant who left an unspent round at the scene that was subsequently matched to a gun that he owned, that he himself asserted was never in anyone else's possessions, who put himself on the bridge at the time of the abduction and wore the same clothing as Bridge Guy. Stacey Eldridge's expert opinion that the defense finally alleges that an affidavit by Stacey Eldridge supports that dirt or water did not cause damage in the auxiliary jack in order to log wired headphones were plugged in and unplugged. They allege that this is newly discovered evidence that would probably produce a different result at the new trial. That Stacey Eldridge testified at trial for the defense, that she did not submit any report, log, or any other information that supported her position that the log accurately supports that headphones were plugged in and later unplugged from the auxiliary jack. No, she's giving an affidavit that supports her opinion that that's not a thing. Dirt or water reporting as an auxiliary jack being plugged or unplugged is not a thing. She's reporting from her years and years of experience in doing this and all the details that she went through to try to verify that. Probably after trial, she probably went back and was like, I've never heard of that, and I'm going to look it up. So there's that. That this opinion was only supported by her testimony at trial, that prior to her testimony, Stacey Eldridge had only done one other forensic phone analysis and had only testified one time prior about a forensic phone analysis, that Stacey Eldridge only gained the education to be able to testify to forensic phone analysis as recently as 2023, that the bulk of her expertise is in computer and network forensics, not cell phone forensics. See her CV, that the state called Sergeant Christopher Cecil on rebuttal to testify about headphones in the auxiliary jack of the phone, that Sergeant Cecil was able to observe photos of the phone when it was found, here in Exhibits 9, 10, and 11, that Sergeant Christopher Cecil did testify that one plausible explanation for the log entry is that there was dirt or water in the jack that caused the malfunction. This is in part based on the condition that the phone was found in, how long it was found before it was found, and his knowledge and experience. So why does his knowledge and experience as a forensic examiner mean something to you but not hers? This is that this is also based on I hate hypocrites. I hate bullies and I hate hypocrites, and he's both. The state is both. This is also based on the facts found through the investigation, including that the phone did not move after 2:32 p.m. on February 13th, 2017, that there were no headphones found with the bodies, that it is unlikely that someone returned to the crime scene after 2:32 p.m., removed the phone from underneath the body of Abby, plugged headphones into the phone, and then kept those headphones in for 5 hours, unplugged them, and then put the phone back underneath the body, all while not moving the phone. No, No, that's not exactly what they're saying. They're saying that the evidence shows that some kind of manipulation was happening with the phone, and at 2:32 p.m., that may not have been the last time the phone moves necessarily, or that it leaves that area. Perhaps it stays in the area a few feet away from where the bodies are because it's on Ron Logan's property. I mean, this isn't that difficult to understand, but let's keep going. That the defense's expert, Stacey Eldridge, sat in the courtroom during Sergeant Cecil's testimony, and the defense had an opportunity to recall her as a witness to rebut Sergeant Cecil's testimony, but chose not to. That there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage because the kind of damage is not registered in the logs, reports, or extractions of the phone. Well, yeah, it would often tell you if there's water damage on the phone. Whether or not there was water damage can only be determined by physically examining the phone, which Stacey Eldridge did not do. But she has physical photos of it and can see that it is in good condition, as is the report. All the reports say it's in good condition too, and it doesn't look waterlogged or dirty. So why are we okay? Whatever. That again, at best, this is impeachment evidence that could have been brought out in testimony during trial that in an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. The same analysis that was used in the above evidence concerning Brad Weber and Ron Logan would apply to the evidence as well. It's not newly discovered evidence. We knew this was going to be their argument, but is impeachment evidence and therefore cannot be the basis for the motion to correct error. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court deny the motion to correct error without hearing and for other just and proper reliefs in the premise. I think she will deny without hearing, and then they will appeal it, which I'm sure, I don't know if that's got legs or not, but it's worth a shot, right? Any little thing. They want the record corrected so they can then appeal the case, but they want that record corrected because there were things that might have been testified to or testimony that was elicited from Nicholas McClellan from Brad Weber, that was not accurate. So in that case, yeah, there needs to be some kind of remedy for all of the things that you guys have done to constantly, repeatedly, over and over again violate Richard Allen's rights. So at some point, this whole thing's going to cave, and Richard Allen's going to be free, and he will be suing the hell out of Indiana State and Carroll County. And I hope and I know he's going to get a good chunk of change because of the egregious way of which they've treated him and his family and acting like he is some kind of rabid animal. I mean, we treat animals better than we treat Richard Allen in prison. So that's all I got to say on that. So hopefully she doesn't wait, Judge Gull, and she doesn't delay this inevitably and before she denies it without hearing, because she's going to do that. So if she's going to do that, just do it so that they can move on and continue with their appeal, because they can't do that until all of this stuff is taken care of. So hopefully we get an answer soon and then they can move forward accordingly. I thank you guys so much for watching my channel, for going along with these court documents with me. It's fun. I would be reading them regardless of whether you're here or not, so I'm glad you're here with me so I can just talk it out and tell you what I think. You guys tell me what you think in the comments below, and I will see you guys in the next one. Take care. Bye now.